All right. Hello. It's me again. By now, you're probably able to recognize my face and voice. I'm just going to say, well, who knows how brief, but I'd like to say some kind of summary, conclusory things about the line of cases that's before us: Sherbert, Yoder, Smith, and Hobby Lobby. It may be that there'll have to be another lecture along these lines. In my experience, once you read the end of the in this case, these lines of cases, but any line of cases, there's a certain kind of residual set of issues that should be taken up and addressed. And in my experience, also, students can certainly use the review, certainly use the repetition. So that's what I'm going to do. The line of cases, of course, is Sherbert and Yoder and Smith and Hobby Lobby. And let me just go through them a little uh, summarily, but hopefully in a way that takes up some of the nagging questions that may be on the minds of some of you. Well, in Sherbert, I have to say, I don't think I adequately addressed this whole issue of the state's purpose uh, being allegedly to prevent fraud. I haven't said very much about it because there's very little argument about it in the case. The court is, I think, quite rightly very dismissive of this defense. And I want to say a bit more as to why. What Sherbert is arguing for is just that um, a more pluralistic understanding of religious observance be included in the set of possible excuses. The question of fraud arises for whatever legitimate excuses your regulations provide for. So if in your state it's considered a legitimate excuse not to show up for work or not to take a job, and thereby not lose your unemployment insurance if you were just hit by a car and you're in traction in the hospital. That's probably on every state's list of acceptable excuses. Or if another legitimate excuse is that your spouse just died and you had to go to the funeral, that's an excuse. My point is that would be probably already pre-existingly listed on the list of acceptable excuses. Whatever your list of acceptable excuses is, fraud is possible. Somebody could try and lie. Somebody could say, well, my spouse just died when they hadn't, or I just got hit by a truck when they hadn't. So the question of fraud, in a way, and the question of what will be included in the list of acceptable reasons that the state will recognize and thereby not penalize the citizen for availing themselves of, were it to be the case that such an excuse were indeed true for them. These are just completely separate worries. When you're sitting around the table with your fellow legislators and you're saying, okay, what are the acceptable excuses going to be? Death of a spouse, will that be one? Serious accident, will that be one? Your religious observance, will that be one? And for any of these acceptable excuses, there's always going to be the worry that somebody might be lying. So you've got to have a whole separate mechanism to detect or police or worry about the lying, just as we do when somebody misses an exam because they were ill. We're not that aggressive about it, but if you do indeed want to worry about this, I guess I'll just show my cards and say, I don't worry about this stuff too much. But if you're a faculty member that does worry about this, then, you ask for a doctor's note or evidence or whatever. But asking for evidence that the excuse applies is a wholly different issue from whether or not a certain kind of consideration will count as an excuse in the first place. And all Sherbert is saying is, look, the Christian who won't work on Sunday, they get an unproblematic pass if there's somebody who offers a job that requires work on Sunday and the believer says, I can't do it, I'm in church. The state of South Carolina isn't giving them any trouble about it. I'm just asking to be treated symmetrically. The question of fraud arises for everybody, for every excuse. That's one of the reasons why I didn't say very much about it. It's almost as if the state is answering a different question when they put fraud forward as their reasons for their, you kind of want to scratch your head and say, wait a minute, that wasn't the question I asked. The question is, why isn't this on your list of excuses anyway? The worry about fraud is a worry you're going to have for any excuse you think legitimate. Okay, so unfortunately, this case is a very weak case for our purposes because we don't have a very interesting rehearsal or presentation of the state's purpose. That's why I want to move on to Yoder and Smith. The only thing the Sherbert case does is it just introduces this test of strict scrutiny, where the state will have to justify its law to a fairly high standard of review. Now, when we move to Yoder, we kind of are on the opposite end of the spectrum here. The state here has a purpose of almost sacred content, educating the young. But as you've seen, as I've certainly stressed, as I hope has come out, exactly how the purpose gets characterized makes an enormous difference, I think, to the outcome of the case. If you think of the state's purpose as giving all students the same level of education necessary in order to decide for themselves what their future might be, then it's very hard to see how they could exempt the children of the Amish, whatever the desires of the parents might be. If the state has a legitimate purpose and they can't, in fact, get this purpose unless no one is exempted, then they would pass strict scrutiny. And I, as you know, think that the Yoder case is wrongly decided, that the state should have won, and that the state, well, let me put it this way, the state's purposes are sufficiently compelling and when understood in the right way can admit of no exemption, so they would have passed strict scrutiny. It's essentially saying to the religious believer, of course we respect your religion, but in this case we're not engaging in some kind of broad sweep of state power that inadvertently catches you up, whereas you really could be left out of this legislation and our fundamental purpose be achieved. That's how the court characterizes the state purpose. The court kind of cheats and says, well, the state purpose really should be understood as simply preparing the children for the life or career that awaits them. And then you say, well, if that's so, then let's just have a more precise, more finely tuned bit of legislation that exempts the Amish from these extra years of schooling. Obviously, as you know, I think that's a characterization of the state's purpose that kind of cheapens or fails to do justice to what I would like to think of as the fundamentally egalitarian impulse behind state policy here. Okay, so that's what's going on in the case with respect to the state purpose. But what Sherbert and Yoder have in common is this strict scrutiny test that once the state law mandates behavior that the religion forbids or forbids behavior that the religion mandates, then the state must justify its law by showing it has a compelling or legitimate purpose and that it really can't give an exemption to the religiously motivated without failing to achieve this legitimate purpose. If the purpose and an exemption are in fact consistent, which is how the court sees the state law in Yoder, then the thought is, well, then do it. If we can accommodate the religiously motivated believer, then let's do it.
That was a crazy plot twist.
Oh, Torm, I can't believe you did this. Well, I'm in the middle of this conversation here. All right. Can you leave me alone for a bit here? All right. So, Torm, you must be quiet now. All right. And then when we move on to Smith, although Scalia has this remarkable argument that the state law is not going to be subjected to strict scrutiny at all. You can imagine, certainly I imagine, that had the court subjected it to strict scrutiny, you would have had a very similar kind of tension as we saw in Yoder. By that I mean, you could imagine that the court might have said, well, the state's purpose is just making, in having this drug law, it's just making sure that the citizens don't harm themselves. And since the religiously motivated peyote use of the Native Americans is unlikely to harm them, this is tied to an ancient, ritual that they've been practicing since before North America was invaded / settled by Europeans. You could equally well say, these drug laws are for others. They're not really for the Native American that is ingesting this substance in the context of a ritual that's gone on for hundreds, if not thousands of years. So the right characterization of the state purpose, having laws that stop people from injuring themselves, is consistent with allowing this exemption. And conversely, a characterization of the state purpose that just insisted on the state's interest in the health of its citizens, regardless of their motivation in taking the substance, would be inconsistent with any kind of exemption. So I would expect a Yoder-like dispute over the purpose of the state, and depending on whether it was characterized in a kind of more pragmatic way. We have these drug laws just in order to stop citizens from getting in a certain kind of trouble or difficulty. And if it's a certain population, i.e. the Native Americans, ingesting this substance in a religious ritual, then we have no reason to think that they're going to go on some rampage when they've ingested this peyote and so forth. And you even see some of these arguments in the dissent that these Native Americans are law-abiding. Drug use or the ingestion of this substance is in no way connected to criminal activity. All the ordinary justifications for the prohibition of ingestion of this drug may not be available when we turn to this population, unless, of course, you make a certain kind of argument about their health, regardless of what they go on to do when they've ingested the substance. Much the same way, in Yoder, you might say, no, this really isn't about giving them the education that they're likely to need, but giving them this more abstract good, the equal opportunity to decide for themselves what their future will be. And analogously, you might say, no, it's not about stopping the Native Americans from doing certain other criminal acts, which is one of the reasons we might have drug laws generally. No, it's just because they're bad for you. And so we don't want you to take them. And that's that. And even though we might not always enforce this law against Native Americans, we want to have it on the books because there could be occasions when we will want to enforce it. So we don't see this debate, and it's a kind of interesting fact, obviously, that we don't, because, of course, Scalia feels, and when you read the Hobby Lobby case, you can sort of understand why he does, the whole project of subjecting these laws to strict scrutiny is so destabilizing that, in fact, there ought to be a second constitutional infringement claimed if we're going to do this. It's kind of interesting when I think about the Smith case. It pits two parties against one another that are both sort of the darlings of the conservatives. It's the state and the religious, and generally the conservatives love them both. And in this case, in the Smith case, Scalia is kind of on the side of the state. He's essentially saying to the religious minority, too bad, no strict scrutiny, you're not going to get it. You'd need a further constitutional rights violation for us to be required to subject this law to strict scrutiny. The state wins. The state gets this extra freedom or lack of constraint in the Smith verdict that in the absence of a further constitutional rights infringement claim, what Scalia calls a neutral, generally applicable law, is not going to be subjected to strict scrutiny. So the state wins and the religious minority just has to eat it, as it were. And there's a really interesting moment in Scalia's opinion where he says, it's true, these minorities are the least likely to be able to get their interests protected in legislation because they're minorities. If you're in a state like Boston, I should have said Massachusetts, or in a municipality like Boston with a very large Irish and Italian population, it's extremely unlikely that legislation that put Catholics in going to Mass and ingesting alcohol on a Sunday in any kind of difficulty would ever be passed. It's just unthinkable that the state legislature in Massachusetts would ever pass any kind of law that wasn't sensitive to the particular needs of, say, Catholics and religious ritual. It just would never happen. And it did happen here in Oregon because the Native Americans just don't have enough political clout. They're not a majority or a sizable minority, and Scalia acknowledges this. But it's a very nice passage where, at least to his credit, he says, yes, I know the courts probably, can reasonably be expected or asked to look after the interests of those who are unlikely to get their wishes expressed in legislation. It's not as if these guys are likely to be able to get a law passed which has this exemption. Nevertheless, he hammers at the arguments he's given and repeats them, and it's not important that I do so here. My only point is that there is, no question, even in Scalia's opinion, that many groups simply just don't have this worry because the legislation that would put them at a disadvantage in their religiously motivated conduct is never going to happen. It's just never going to happen. All right. In this case, as I say, Scalia favors the state, or he gives an argument which makes it the case that state power has one less thing to worry about. It's less likely that a neutral, generally applicable state law will be subjected to strict scrutiny under the Smith analysis. But Congress is so upset, they pass legislation that requires the courts to apply strict scrutiny to cases where the religiously motivated conduct conflicts with a neutral, generally applicable state law. And that, of course, is what we have in the Hobby Lobby case. And now the state is the Affordable Care Act requiring employers to provide contraception for their employees. And the religious minority are the owners of this company, Hobby Lobby, whose religious beliefs see this contraception as sinful, as wrong. And nobody claims they're certainly not entitled to that view. Now the question is whether or not they can use their sincere convictions along these lines as a way of, I want to say, it's two things. They want to avoid compliance with the Affordable Care Act provision that requires them to provide this contraception. They want the law that does not allow them this avoidance to be declared unconstitutional. And now we come to a very important and short and possibly final point in this little lecture. The strict scrutiny test, as it's presently understood, really seems to have an extremely expansive, almost semantic understanding of possible or could. And so the question, is this the most narrowly tailored law possible, which is essentially the same as could the state or the government give an exemption and still pursue its purpose? The court understands these notions of could and possible in an extremely expansive way. It's not, would it be inconvenient for the government or the state to provide this exemption? Is it possible? And possibility, as anybody who sees, the movies that come out of Hollywood knows, it's a very rich notion. Lots of things are possible. I mean, I won't even begin to list all the things that might seem to be possible when you watch certain kinds of science fiction films and the like. And certainly it's possible to imagine the government simply doing what it asks here the citizens to do, which is providing these women with the contraception that the religious believer thinks of as wrong and sinful. And so, given what strict scrutiny seems to be, it's kind of hard to blame the court for finding that the Affordable Care Act just has to be amended in ways that allow the religious believer not to be compelled to provide this contraception, since for the religious believer, this contraception is wrong. But here's the important point, very important point. The government could provide it without the religious believer having to get involved. It's possible. It could happen. It's not in any way as if the court is saying the provision of the Affordable Care Act is wrong or unconstitutional. If anyone says this on the midterm, it'll break my heart and you won't get any credit for your answer. No, it's not that. It's just that given what the strict scrutiny test actually is, it's the test of whether or not, there's some other arrangement. This is the most narrowly tailored means idea. There's some other arrangement that it's possible that the goal in question could be achieved without compelling the religiously motivated citizen to go against their religious convictions. That's all. It's like saying, do we have to coerce the religious too? And in the case of the Affordable Care Act, it's sort of like hard to see how the government thought they really could possibly prevail here. Given that the government could have just done this directly in the first place, it's very hard to argue. No, you have to provide it. It's no good unless you have to provide it. I mean, from a certain point of view, of course, as liberals, you might want to make these religiously motivated actors comply with these progressive ideas. But what you really want and what the law is really about is just making sure these women get the contraception. I don't see what difference it makes if, were to fall from the sky. I mean, and certainly if the post office were just to deliver it, that's what you want. You want the service. It's the religiously motivated employer is not a necessary part of this particular policy ambition. So in some ways, of all the cases we look at, here, the state's argument for compelling the religiously motivated actor just seems to me among the weakest. The government has an interest in making sure, because it's really not the behavior of the religiously motivated actor that the state can really care about. It's the provision of the health care. In the Yoder case, we want the kids to go to school. That's what we want. And in the Smith case, we don't want people to take drugs. That's what we want. But in the Hobby Lobby case, is it really important that the employer give the benefit to the employee? No. What's important is that the employee get the benefit. That's what we want. If somehow, like through a direct governmental policy, of the kind that some, of course, support, you got this medical service, contraception, through some other means, then you've achieved your policy goals that way, that the religiously motivated employer is the one that's, it's like some complicated Rube Goldberg. The law is passed. The religiously motivated employer has to buy an insurance for the employee, and in that insurance is a certain feature in which they get the birth control. Yeah, sure, fine. But what you really want is that final outcome where the woman, in the end, gets her birth control pills. That's all. So it's in some ways the government's position in the Hobby Lobby case, from where I sit, is just extremely weak. If you're a supporter of a single payer, you look forward to a time when there just wouldn't be these kinds of lawsuits, because you wouldn't have the employers at all involved in the provision of medical services. So it's obviously possible that they not be involved for religiously motivated reasons too. All right. A few final thoughts. I'd be curious if any students have any thoughts. In the Smith case, one of the dissenters says it could have been Ginsburg. I'm not sure. I'd have to look at the case. The beauty of the strict scrutiny case, it's kind of finger wagging at Scalia for it has to be a general, neutrally applicable law. And Sherbert wasn't that. And, here we don't have a second right. And I believe it's Ginsburg who says this is just nonsense. If we're going to be serious about preserving what the founding fathers wanted, which was, respect for religiously motivated conduct, we want to make the state go through this justification story. And I think there's a lot in that. I think that's a very noble aspiration. What Hobby Lobby shows, though, is that I think this justification probably best revisited, probably best made a little less demanding, a little less perfectionist. As it is, the justification the state must show is really that it isn't possible for it to do anything but coerce the religiously motivated actor. And my hunch is there's a more modest way of understanding what you might call not exactly the strict scrutiny test, because as it's understood, the strict scrutiny test does, in fact, have this very high standard of justification. But perhaps what's really wrong at the end of this line of cases is just this. And perhaps the state it would be better if the state need only show that it achieves all kinds of good goals, if it can coerce the religiously motivated, that the religiously motivated are hardly being coerced in matters that have to do with their religious practices. It's not as if, they're prevented, as in the Sherbert case, from actually going to their church on the day that is their Sabbath. There might be a way of understanding the justification story the state must take up a little more modestly, such that the state would have a better chance of justifying its laws in cases like the Hobby Lobby case. Scalia warns us in just these alarmist terms in the Smith case. If, we really are going to subject any law that commands X or forbids Y to strict scrutiny, so long as there's a religiously motivated believer whose beliefs require them to refrain from X or engage in Y, I think his words are, would court anarchy. We're looking at anarchy, because any person then has, as it were, the private right to subject an otherwise perfectly good law to an extremely demanding test. That was his point. Now, his solution is this kind of phony argument in virtue of which strict scrutiny won't be applied at all. Not that this could ever happen, given all the things this country has to take up and worry about. But you might, at the end of this line of cases, think, this is kind of what I'm thinking this year. The problem is the test is just a little too demanding. That's why Scalia, as phony as these legal arguments are, he's on to something about his queasiness, his ill at ease with subjecting these laws to strict scrutiny is not without justification. The solution, it seems to me, would be to have a somewhat more modest, slightly less demanding version of the strict scrutiny test. But I'm kind of wasting your time saying this. I'm not going to ask you this. This is not real legal knowledge. This is just Steve Ross speculating. What I want you to do is just see the ways in which the strict scrutiny test is understood in this very demanding way. And given that, the Hobby Lobby case, I think, is correctly decided. I certainly can't see, if that is the test, how you could possibly think the government has to have these people provide these women with the contraception. And obviously, you can imagine all kinds of problems along these lines down the road, but I'm not going to take that up now. I'm only saying that given the ways in which in this country we look to private actors, particularly employers, to enforce or carry out all kinds of public policy mandates or orientations, conflict with the religiously motivated actor is inevitable. But what you really got to understand is the strict scrutiny test how characterizing the state's purpose can affect how the test is applied, but also, however the state's purpose is characterized, it's going to be understood in a very aggressive, ambitious way. Simply asking if it is possible for the state to pursue this purpose consistent with an exemption, or whether the state could pursue its purpose consistent with this exemption. It's a very, very demanding test. Funnily enough, I think in one of the few cases where the state could meet it is Yoder. I think the state really had a perfectly good answer. No, we really can't get what we want if we give an exemption. And that's why I think, because the Amish were such a sympathetic plaintiff, the court kind of fudges on what the purpose is. All right, I'm going to stop it there. Please let me know if you have any questions, and we'll begin the establishment cases very soon. Thanks.